Thank you for joining us today for the RTA webinar, and our topic is the overview of 1 May 2025 rental law changes, Part 1. Now, before we start, I'd like to acknowledge the traditional owners on the land on which we meet today and where you are joining us as well, and pay our respects to elders past, present and emerging. My name is Lynn Smith and I'm joined today with my colleague Mark Vidler. Mark and I are in the education team at the RTA. We both have been at the RTA in various roles for around 20 years each and bring a wealth of knowledge and experience with tenancy laws for Queensland. Thanks for partnering with me today, Mark.
No, thanks for having me, Lynn.
This recording has been split into two parts. Today we will do part 1 and look at the journey so far with the rental law reforms, and then dive into the topics you see on your screen for the changes occurring from 1 May 2025. Please note, a separate recording is available for part 2 on the topic of the new tenancy application process. During the session, Mark and I will look at questions we've been receiving at our events and answer those questions for you. Remember, as always, the RTA is here to help you navigate these changes and to help the sector understand their rights and responsibilities. For those not familiar with the RTA, we are an independent statutory body and our services include our contact centre. We offer a free dispute resolution service. And as Queensland's rental regulator for more than 30 years, we also undertake proactive and reactive monitoring, compliance and enforcement activities. We hold and manage over 600,000 rental bonds, and we also work with the sector stakeholder groups. And the RTA's core function is to administer Queensland tenancy laws. We do not write the legislation. Our role is to help all parties in the tenancy understand their rights and obligations. Now, if we look at the rental reform journey so far, this started back in 2021 with the Housing Legislation Amendment Act 2021. The key changes were implemented in stages during 2022, 23 and 24. Last year, the Residential Tenancies and Rooming Accommodation and Other Legislation Amendment Act 2024 was passed in Parliament, and again, the key changes were implemented through a staged approach. We're now going to have a look at the changes commencing on 1 May 2025. If you want to know more information about the previous changes or the history, please visit the RTA's website and search for rental law reform. First, let's talk about personal information. In today's world, protecting privacy and personal documentation is important to everyone. There will be new limits applying to the personal information that a property manager or an owner can request from a tenant or resident, and a timeframe outlining the securely storing and destroying of personal information to be done by a manager or an owner. Now, this does apply to both physical and digital records that may be collected and stored during the application process or throughout the management of the tenancy. We are often asked, what is personal information? Now, the Act refers to it as information or an opinion about a specific person or someone who can be reasonably identified, and whether it's true or not. It also covers photographs or images of someone's personal possessions or standard of living. So this could capture any photos taken during a routine inspection as well. Now, the timeframe is split into two areas: prospective tenant information and a tenant or resident who is in the actual tenancy. Let's look at the prospective tenants first. So this will include their application and personal documentation, and it must be securely stored, accessed only by the relevant persons assessing suitability, and destroyed within 3 months if the applicant does not become the tenant. A prospective tenant may choose to agree in writing for a longer period. Now, for a tenant or resident in the tenancy, it must be securely destroyed within 7 years after the end of the tenancy or rooming agreement. Now, keep in mind there are still the requirements under the Act for storing normal tenancy paperwork such as your tenancy agreement, entry condition reports and rent payment records. This still remains the same, nothing has changed in this space, and an owner or manager must keep these records for at least 1 year following the end of the tenancy. Now I'm going to invite Mark back in. Let's go through some of the questions that we've been receiving in relation to this topic. So what information can be collected by a manager or an owner during the tenancy?
Yeah, thanks, Lynn. Look, information can be collected if it's related to the management of the premises. So this might include photographs taken during property inspections, for example. So these would be considered part of the information necessary for managing the premises.
Thanks, Mark. And what happens if a tenant or resident still owes money after 7 years? Can an owner continue to hold on to that personal information of the tenant?
Yeah, look, it's a good question. The Act does not provide an exception, is the simple answer. Look, all personal information related to the tenancy must be securely destroyed within 7 years after the end of the residential tenancy or rooming accommodation agreement to which the information relates. Customers might need to consult a legal representative regarding the statute of limitations in Queensland relating to personal debt in order to be able to follow that debt up if they still can.
That's good to know. Thanks, Mark. And what happens if the information is stored offshore or not stored locally?
Yeah, so this question's come up a little bit. Look, the upcoming requirements specifically address the collection, storage, and destruction of personal information within the context of residential tenancies. The Act doesn't make any reference to where the information must be kept, only that it is stored securely and only accessed by relevant persons. So if your storage is offshore, then probably not a problem as long as it's secure.
And comply with the rules. Yeah.
Yeah.
Um, so if photos have been sent to an owner from a routine inspection, do they also have to destroy the information within 7 years?
Yeah, in a word, yes. So, and this is where parties who collect and store personal information will need to be alert as to where information's kept. So, sent emails, for example, with photos attached, will also need to be securely destroyed. Paper documents might need to be shredded. So, you need to keep tight records on where you've got information and ensure that after that 7 year period, everything is securely destroyed.
Great. Thanks for that, Mark. Okay, so our next topic is around entry notice period and the frequency of entry from 1 May. The legislation outlines the rules of entry and timeframes. The entry notice periods that are currently 24 hours will be increased to be 48 hours. And this will be for situations like showing a prospective buyer or a prospective tenant through the rental property, doing repairs or maintenance, entry for valuations, etc. There is an exemption for rooming accommodation for cleaning, and that remains at 24 hours. Please keep in mind mutual agreement between a tenant and the property manager or owner or the secondary agent is still available. So the other change is once a notice to end the tenancy has been issued, now this could be a property manager or an owner issuing a notice to leave or a tenant resident issuing a notice of intention to leave, then the frequency of entry to enter the rental property will be limited to no more than twice in a 7-day period. Now, the purpose behind this was around quiet enjoyment when the tenancy is ending and the tenant is packing up their possessions to move. With regards to the frequency of entry, if there is a secondary agent, so as an example, maybe like a selling agent or another person looking to gain entry that may be different to your managing agent, they need to be aware of any notices that may have been issued to end the tenancy. So, what does this look like? And we're just going to step through an example. So just to clarify, the 7-day block of time starts when that notice has been issued for ending the tenancy. So in this case, as you see on the slide, it's been done on a Tuesday. So the examples show 3 types of entries to occur and the correct notice has been issued. Yes, for the first one, it's a routine repair and that's okay for the Thursday. Yes, for the second is the inspection on Saturday to show prospective tenants and that's okay. But come Monday, that Monday inspection would not be okay as it falls within the 7-day period and would be a third inspection. Now, the entry provisions for emergency repairs, compliance for fire and electrical safety are exempt. So is mutual agreement if both the tenant and the manager or owner agree. So, in other words, the emergency and compliance types of entries are permitted to occur and are not restricted for that 7-day period. So, Mark, I'll get you to come back online And has the entry time frame for general inspections changed?
No, Lynn, a general inspection is still 7 days and not less than 3 months since the previous entry for the same reason. And in rooming agreements, these timeframes remain at 48 hours and 1 month between inspections.
Great, thank you. Now, if a notice to leave due to end of a fixed term tenancy is issued at the same time of signing the agreement at the start, am I captured in the limit of frequency throughout the whole agreement, or is it just towards the end of the term?
Yeah, good question, Lynn. We're aware of this practice still occurring, even though we consider it to be against the spirit of the legislation. And the answer is yes. If you issue a notice to leave at the start of the tenancy, you'll be limited to no more than 2 entries within a 7 day period for the duration of the tenancy, unless, of course, you can obtain mutual agreement from the tenant or you need to enter for one of the excluded reasons.
Great, thanks, Mark. Now, if some repairs need priority attention, can an owner enter before the 48-hour notice?
Yeah, so the Act provides exemptions from the 48-hour requirement for emergencies and to protect the premises from imminent or further damage. But if you've arranged for repairs to be done, you do need to provide an entry notice with 48 hours, unless you can obtain mutual agreement from the tenant to enter earlier. Now, let's consider that if a tenant has requested repairs, then they're likely to want them done and likely to provide that mutual agreement, especially if it's tricky to get hold of a tradesperson or something.
Excellent. Now, does a sales agent still need to give a copy of the entry notice to the managing agent for each inspection?
Yeah, look, another good question here. So the Act hasn't changed regarding the requirements here. So a secondary agent, which is usually a selling agent, has to provide a Form 10 either before or when the first entry notice to show a prospective buyer is given to the renting agent. And also, unless the renting agent agrees otherwise, a copy of each entry notice that they're issuing to the tenant. So, the process here um, sort of helps eliminate the risk of entering more than twice in a 7 day period. So by notifying the renting agent that entry needs to take place, they can let you know uh, whether you're going to be reaching that requirement.
Excellent. Thanks, Mark. Now, the next change is around putting an official process around the request for fixtures and structural changes. Now, there will be a new form, a Form 23, for the tenant or the resident to complete when requesting any fixtures or changes. Now, a property manager or owner has then 28 days to respond to the request. Now, also note too here is that if no response is given, then it is not approved. So, unlike the pet approval framework that occurred a couple of years ago, this section does not have an automatic approval when there is no response. So, the approval must be in writing, describe the fixture or the change, and specify any conditions. Conditions as part of the approval may include the maintenance responsibilities, permission to remove the fixture, or procedures for removal if it is allowed, repairing any damage, or compensation if removal is not allowed for the improvements made. Now, please note too, for any units, apartments, or townhouses, there may be a body corporate bylaw, and therefore a body corporate approval requirement is required. It also is a separate process and the 28-day timeframe does not apply. So keep in mind that there's probably two parallel processes running at the same time. This is really relevant if it impacts the external appearance of a lot. So for more information, visit the Body Corporate Commissioner's Office website about the body corporate rules and processes. So let's have a look at some of our popular questions in this space. So is there a standard response form for owners to complete to reply to the request?
No, Lynn, there isn't, but page 3 of the Form 23 provides for an owner's response, and it provides the ability for them to give 3 key pieces of information back to the tenant. So those 3 key pieces are whether or the approval has been approved or not, a description of the fixture or structural change, and then any other conditions around the approval that either that might state reasonable conditions for the approval, or if the approval is subject to an agreement by a body corporate, as you just mentioned.
Does an owner have to give a reason to why a structural change is not permitted?
No, they don't. but the legislation states that the lessor must not act unreasonably in refusing the request. So if it is refused, the tenant may continue to communicate with them about the request to the point of coming to the RTA for dispute resolution, and ultimately, if it's unresolved, then off to QCAT for them to make a final decision on it.
Can an owner request that the work be carried out by a professional contractor rather than the tenant doing the work themselves?
Yeah, they can. As one of the conditions of approving the request, they most certainly can request that it's done by a professional. Yep.
Can an owner or manager request longer than the 28 days to respond?
Yeah, they can. The Act actually states, Lynn, that they have 28 days to respond, but it does also say that if agreed to by the lessor and tenant, a longer period can work in this situation. So again, communication and talking to each other about the process.
And can QCAT make a decision if a dispute occurs?
Yeah, it certainly can. So I mentioned a little bit earlier that if the owner refuses, then the tenant can come to the RTA for dispute resolution. So if that process is unresolved, then they can pursue the matter through QCAT. Now, when it gets to QCAT, they'll consider the sorts of things around how the change might improve, safety, security, or accessibility for a tenant, whether building approval is needed. And then, maybe even whether the change can be removed or if the premises can be restored after the tenancy. So that link's not exhaustive. So that list is not exhaustive, but I would suggest jumping onto our website to have a look at what QCAT will consider in that process.
Thanks, Mark. Now, finally, any financial benefits received by a property manager or owner regarding rent payments must be disclosed. So, if a manager or an owner is using a third party platform where there is a financial benefit provided, then that will need to be disclosed to the tenant. And as a final reminder here too, tenants do need to be made aware upfront, of any costs involved in paying rent. This came into effect last year. However, penalties now apply for both of these situations as of 1 May. If you'd like to know more detailed information on today's topics, please scan the QR code on the slide and it will take you to our specific law changes page on our website. We have fact sheets, information, videos, podcasts available with more information regarding these changes, and we'll continue to create more content to ensure that the sector is informed and educated. This page will also have the FAQs where there's a list under each heading and most likely will answer a lot of your questions. One of the key changes on 1 May is the new rental application process. So please watch part 2 of the overview of 1 May rental law changes for more information. We have a lot of information. Thank you for joining us today for the RTA webinar, and our topic is the overview of 1 May 2025 rental law changes, part 2. Recording has been split into 2 parts. Today we're going to dive into part 2, which is about the new tenancy application process. For other changes occurring on 1 May, please go to part 1 recording to learn more. During the session, Mark and I will also look at questions that we've been receiving from our events and answer those questions for you. Now remember, the RTA is available to help you navigate these changes and to help the sector understand their rights and responsibilities. If you want to know more information about the previous changes or the history of the rental law reforms, please visit the RTA's website and search for rental law reform. So one of the key changes commencing on 1 May is the new standardised rental application form. Now there'll be 2 forms, one for general tenancies and movable dwellings and another one for rooming accommodation. So a Form 22 and a Form R22. This is to be used for when a prospective tenant is applying for a rental property. Property managers and owners will need to provide 2 ways to submit an application and ensure an option to submit the form is available other than using a restrictive way like an online platform hosted by someone else that is not the property manager or owner. So as an example, If a manager is using an online or digital application, they'll need to make sure that they offer another option, such as maybe like a paper form, making it accessible for all prospective tenants. There are also guidelines on what information can or cannot be requested from a prospective tenant during the application process, and I'm going to step you through that shortly. Now, it's also noted here too that the legislation uses some new terminology regarding a relevant lessor. So, in a nutshell, there is a general exemption for social, community, and public housing organisations as part of this process. This is for organisations that fall in the categories of coverage under the Housing Act 2003 or funding under the Community Services Act 2007, or is a state or a replacement lessor under a community housing provider tenancy agreement. We note that the Act and regulations are very clear about what the requirements are for the application form and process. Any applications submitted before 1 May but will be processed after 1 May will not be captured under the new laws. However, any applications submitted from 1 May and onwards will need to. The legislation outlines what information or documentation can be requested in the application. So name and contact details, current employment, income details, referees information, the term of the tenancy, details of any previous tenancy or rooming agreement, and any other information prescribed by regulation. Now, what we do know is that in March, the regulations were released and what they include to add in the application form, and I'll cover that in the next slide. The regulations allow for additional information to be captured on the application form. This now includes date of birth, number of tenant residents to reside, and number who are under 18 years of age, number and type of vehicles to be housed at the property, so whether a car, boat, heavy vehicle, or a motorbike, and also financial ability to pay rent. So this expands the options for income details and also the number and type of pets to be kept at the premises. There is also a limit of no more than 2 documents in each of the following category: identity verification, financial ability to pay rent, suitability of the prospective tenant and resident. Now, a prospective tenant may choose to show or provide a copy of the documentation. If a document is accessed or cited by the property manager or owner, they must not keep a copy of the original identity document without the prospective tenant's consent. There are penalty units in this field. And a reminder too, if a manager or owner seeks more than the limited documents in each category, again, that there are penalties. A manager or owner cannot request directly from the tenant evidence of legal actions taken by a prospective tenant or resident, including disputes or matters considered by a tribunal, information on previous remedy breach notices, the prospective tenant or resident's history regarding rental bonds, including any claims, any statements that detail a potential tenant resident's credit or bank account transaction history. Now, the Act does not prevent a prospective tenant voluntarily providing extra personal information. A prospective tenant or resident may wish to volunteer further information if they wish to do so. Additionally, the process of asking a referee for information has not changed. There is no restriction on what information can be requested from a referee, and this includes asking a referee about a past bond claim or if there's been any breaches in the tenancy history. This particular section only relates to the information that a property manager or owner can ask about the tenant directly from the tenant. While the application form and what information can now be asked for or provided as part of the supporting documentation is covered by the legislation and regulations, the selection process or business process doing the selection and referee checks still remains the same as what may be as current practice. The decision to approve or not approve is still up to the property manager or owner at the end of the day. The application is putting a structure around what an owner or manager can request. And what you may find is that now that there's a standardised application, tenants may start completing it early and getting information ready before inspecting the property, which may help streamline the time frame. Again, a tenant may volunteer more information, but for an owner or manager, they cannot ask for more than the requirements in the legislation. The ability to ask questions of a referee or obtain a rent ledger is still there when making those decisions. With the new Section 57B to D, the rental application process, we know that there are penalty units applicable. So just outlining that not using the standardised application form or not offering two ways to submit an application or requesting personal information or more documents than the guidelines allow all have penalty units attached. Now, if a manager or owner is using an online platform, they need to ensure it meets the legislation requirements and is compliant. Thanks for your patience, Mark, as I invite you in now just to answer some of these questions that we have in this topic. First of all, can I use my own version of the application form?
Yeah, Lynn, it's the responsibility of the property managers or owners to ensure that their application form is compliant with the Act and the regulations. So the RTA encourages property managers or owners to use the application form available on our website to avoid any non-compliance with the Act. But we also recognise that uh, software providers will provide, put the application form into their system. As long as it's substantially compliant with the form that we have produced, then it should be okay to use.
And as always, isn't it, Mark? We always encourage people to make sure that you check online on the RTA's website for all our forms to make sure that you are using the current and relevant forms.
Correct.
Can a property manager ask a referee about previous breach notices or bond claims as part of the referee check? Well, we did go through that, but just to clarify.
Yeah, you have been pretty clear on that, but to verify the Act prohibits property managers or owners from obtaining that sort of information directly from the tenant, but it doesn't extend these restrictions to third parties or other entities. So while property managers are not prohibited from accessing such information from external sources, the RTA does encourage them to focus on assessing the prospective tenant's ability to meet their tenancy obligations, when deciding whether to approve an application or not.
And what if a tenant does not have a pay slip as proof of income?
So documents that can be used to verify a prospective tenant's ability to pay rent may include payslips, might be bank statements or other financial documents. But if the tenant's not receiving a regular income, so they're self-employed or casual or freelance or something along those lines, then they might include previous details of employment or other documents supporting their financial ability to pay rent, such as payslips from previous employment, bank statements without the transaction details to demonstrate proof of savings or assets, Centrelink payments or statements, proof of savings or assets. But we would encourage the tenant to have a conversation with the property manager. So, let them know and talk through the process or the situation with them and provide what information they can. Again, it's that communication.
Excellent. Now, if a tenant shows ID, can a property manager still write down those details?
So when providing identity, a prospective tenant can either provide a copy of the original identity document or allow the property manager or owner to access or cite the original identity document. And if they only allow them to access or cite, then the property manager shouldn't be recording any of that information.
And finally, can the RTA's dispute resolution service help if an application's been declined?
No. And that slide that you put up with the 4 points, the property manager or owner makes the assessment based on the information that the prospective tenant has provided and determine whether the application is successful or unsuccessful. There's no capacity for a prospective tenant to dispute the decision that's been made. So our dispute team is there for matters once the tenancy started.
So during the tenancy or if there's like a bond dispute at the end.
Correct. Yep.
Thanks, Mark. If you would like to know more information on today's topic, please scan the QR code on the slide and it'll take you to our specific law changes page on our website. We do have a lot of information, fact sheets, videos, podcasts available about the changes, and we will continue to create more content to ensure that the sector is informed and educated. So this page also does have our list of frequently asked questions, and most likely you will probably find an answer to a question that you may have. So for information regarding the other changes commencing on 1 May 2025, please watch part 1 of the overview of 1 May changes May rental law changes. We have a lot of information and education on our website at rta.qld.gov.au, or you can check out our other channels such as our YouTube videos or podcasts. Our Friendly Contact Centre is available to assist you on 1300 366 311. And for social media, you can follow us on LinkedIn as well as Instagram. We hope to see you at one of our upcoming events or one of our future webinars. Thanks very much for joining Mark and I today.